Estate planning deals with two things: deciding who will assist you if you become mentally incapacitated, as well as deciding who will be in charge if you pass away. A trust is an agreement between three parties: an owner, a manager, and a beneficiary. Now, when you set up your trust, you are actually all three of these individuals. You're the owner because you own the home, for example. You're also the manager because you get to decide when to refinance, when to rent, or when to sell. And you're also the beneficiary because if you sell the house, you can benefit from the proceeds of the sale. Now, in your estate plan, while you are the trustee, if you subsequently become sick, you've already determined, for example, that your adult son will serve as the manager. Because you're still alive, you will continue to be the beneficiary. However, once you pass away, you've already decided through your estate plan who's in charge and who will inherit from your estate. When this happens, everything is in place and those individuals will come forward to manage your estate plan. Funding your assets in your trust is one of the most important aspects of setting up a proper estate plan. For example, if you get sick, your trustee will be able to manage your home, your bank accounts, and your investments, so long as they are titled in the name of your trust. I'll review 4 examples of funding your assets. The first is a home. The second is a bank account. The third is a non-retirement investment account. And the fourth is a life insurance policy. For your home, if your name is John Smith and your trust is called the John Smith Trust, you will need to transfer ownership through a deed, execute that deed, and properly record it in the county where the home is located. For your bank accounts, you'll need to sit down with a banker and transfer ownership from you as an individual to you as a trustee or manager of your trust. Similar to a home, your accounts will be titled in the name of your trust. For a non-retirement investment account, this is exactly the same as a bank account, where it will be transferred from you as an individual to you as the manager of your trust. And finally, a life insurance policy. This is called beneficiary designation. So if you are a single person, you will list the trust as the primary beneficiary. However, if you're married, you have the option of listing your spouse as the primary beneficiary while listing your trust as the secondary beneficiary. Making sure your estate plan is up to date is of paramount importance. So therefore, I recommend that you review your estate plan every 1 to 3 years to confirm that the decisions that you've made are appropriate in the event of your mental incapacity or passing. And essentially, you're looking at any relationship changes or updates, births, deaths, divorces, for example. You're also looking at any asset changes. Did you sell? Did you buy? Did you refinance? Generally speaking, your assets need to be either titled in the name of your trust or else the trust needs to be listed as a beneficiary. Now, the final reason is any tax changes happening at either the state or federal level. Our law firm generally reaches out to you every 3 to 5 years to meet with you to review your estate plan and discuss any changes. So if you want your affairs to be carried out in the way you desire, I recommend that you set up an estate plan before you have a life-changing event.